To order of the Senate Public Safety Committee. Thank you for being here at this later hour as our legislative session went longer than anticipated. But we have now 6 bills on the calendar, I believe. I think this is an old agenda, 5 or 6. We're going to begin with Senator Cowsert, as we had to make some minor tweaks to some Scrivener's language onto his bill, and weren't able to hear it yesterday. And I'm going to turn it over to you, Chairman Cowsert, to introduce Senate Bill 490 and make sure everyone has the right substitute. We are looking at LC 394276S. Is that correct?
That is correct.
All
Thank
right.
you so much, Mr. Chairman. I apologize for being late to your meeting the other day, but as it evolved in our conversations, we realized there were several ways to improve the bill, hence your committee substitute. Generally speaking, this is for the offense of fleeing from a police officer or attempting to elude a police officer. We've had quite a bit of problems with law enforcement being sort of stymied in their attempts to make legitimate traffic stops by the drivers just taking off and fleeing. Turns out the consequences for that were very lenient. It took up to a 4th offense to be considered a felony. And what this bill does is narrow it down. It just lets it be 3 strikes and you're out. So now a 3rd offense becomes a felony. But the 1st and 2nd are misdemeanors that are high and aggravated misdemeanors. They can be fined by not less than $1,000 or more than $5,000, or confinement of 30 days to 12 months, or both. The original version, this has been cleaned up a little bit, I believe, made it sound like you had to fine them and imprison them. I think now we've made it clear it can be either or, left up to the judge. Did we get that changed, Mr. Chairman? I'm looking.
I believe so. Let me just get to that part of the bill.
Okay. I'm wanting to make sure it's an and. It's not required that there be both. I guess or both covers
Yes,
that.
or.
Okay.
Yeah, you have a choice with an or.
All right. That's what we wanted to make sure we did. And that's the gist of it. There's just been so much, so many situations where their lives are being put in danger by high-speed chases, particularly in congested areas, and so we're trying to put an end to this, but allow some mercy for a 1st or 2nd offense for like a young kid that's out driving somewhere he's not supposed to or whatever and needs to mature a little bit and follow what the police officer says instead of trying to scoot. There is in the code section a section that says if you are going more than 20 miles over the hour or putting other folks in danger, committing these violations, you'll see them there on line 75 through 81. Those can be, if you're committing those offenses while fleeing, it can be a felony even on the 1st offense.
Thank you, Senator
You'll see,
Cowsert.
really, that starts up there at line 69. If you're going more than 20 miles an hour over, if you collide with another vehicle or pedestrian, or you're the cause of an accident, or you put the general public at risk, or do any of these serious violations, then it's a felony even on your 1st time. So we're happy to answer any questions.
Thank you, Senator Cowsert. I think we are still giving the opportunity for leniency here. We just don't want to give a 2nd chance, a 3rd chance, a 4th chance, a 5th chance. Is that a fair statement?
That's right. This takes it, current law, you get 4 strikes till you're out on a felony. We're getting it back down to 3, leaving the rest of it intact.
All right. Questions from the committee members for the bill's author? All right. Seeing none.
Thank you.
We do have one person signed up to speak. Chairman Couch, you can stay there. They can go up to the.
Okay.
Oh, you're waving off? Okay. All right. All right. All right. So, Ms. Maisie Lynn, you are happy now? We'll put you off the list for this bill. All right. I've got nobody else signed up on this bill. Is there any further discussion? Committee members? Seeing none, I'm going to recognize the Vice Chairman.
Thank you, Mr. Chairman. Motion do pass.
I have a motion to pass. I've got a second from Senator Jackson. She beat Senator Halpern out. Is there any further discussion from the committee members? Seeing none, all those in favor, please say aye.
Aye.
All opposed, please say no. Passed unanimously. Thank you, Chairman Cowsert. Best of luck in the Rules Committee.
Nobody can say we don't respect our elders.
Just got to be careful to turn that microphone off. All right. Next up, Senator Harbin, why don't you come on down here? We're going to talk about some seat belts. And I want everybody to look at the video. We're going to play this a couple of times, but I don't want it to be distracting. I think you can watch and then let him.
This is actually at 25 miles per hour. If you look at what's going on, you're going to see a seat in the back seat. One occupant does not have their seat belt on, and one does. And if you look at what happens, the person in the back seat without the seat belt goes completely over the top of the front driver into the windshield. Here you'll see it again. Airbags deployed. The person comes over the top into the person in the front seat, and you can see that's at 25 miles an hour. That's one of the things I was very surprised that this had not been required, is that current law does not require your rear seat belts to be on except for children and those under 8 years of age. Interesting that 50% of all auto accident fatalities occur because the driver is unbelted. And that's a part that we have to realize. 60% of the back seat fatalities occur without seat belts. And traffic, the mortality side as far as this, if we would wear the seat belts, I mean, we're talking about cutting many lives as far as that. They're estimated that 15,000 lives would be saved, just people across the nation, if they were all wearing their rear seat belts. Here's another part just to think about, and this came up in one of the articles that I read, is that we have Uber and Lyft. The majority of people do not wear their seat belts when they are doing a ride share. And what we are seeing, the article was talking about that many of the Uber and Lyft drivers are asking the passenger to wear their seat belts, because you can see what happens is the person in the rear seat becomes a missile to the person in the front seat, and actually the damage to the front passenger is caused by the unbelted person in the rear. So that's where this kind of came from, and you have to realize that not wearing your seat belts, I always say NASCAR wears their seat belts, you ought to do it too, because if you're in Atlanta driving in their traffic, you're almost like that. But I think that's something to see. If you look at the bill, it's pretty simple. If you go to page 2, what we do is we simply scratch out the word where each occupant, and we scratch out front seat. So now it's anybody that's a passenger in the car, and that such person, the passenger vehicle, is operated on public roads, streets, highways, et cetera, et cetera. So what we do is we make that the standard, that it's anybody in the car, front or rear seat. Also, a notation on page 3, you'll see lines 63, 64, 65. We're dealing in 66, dealing with 8-year-olds, but since we have it 8 years and under is already required, this just says that if they're over 8 years of age, they are a passenger just like an adult is from that standpoint. Just kind of FYI information-wise, under the code, I had some farmers complain they didn't want to wear their seat belts, but under the OCG code, it does have an exception. It says that pickup trucks being used by an owner, driver, or occupant 18 years or older in connection with agricultural pursuits that are usual and normal to their farming operation have an exemption. So that's something that's built in there. Just kind of a FYI from that standpoint. I see it as a very simple requirement, but here's the part I would say. It causes me, when I get into the car and I'm driving, to tell my passenger, would you please put your seatbelt on, not for you, but for me.
Well said, Senator. I appreciate your testimony and good work on this bill. Are there questions from the committee members to the bill's author? I've got one from Senator Jackson.
Thank you, Mr. Chairman. So we're actually talking about mostly adults here who are riding in the back seat. So rideshare is your example. I think it's a really great one. Who gets the ticket? The adult that's in the back seat or the driver?
The way it reads is that it is the passenger that gets it. It's a $20 ticket, I believe. 25 now. Yeah, 25. It had been 20, and a 25 that's there. And let's see, go back over because we didn't change it there. But 25. And here's the part, what I see right now.
Can
is
you show
that,
me where it shows?
Page 369, line 69, may not be fined more than $25.
But it's the driver of the passenger vehicle shall be guilty.
That's if it's a child.
It's
If
child.
it's a child.
Child,
Okay.
yeah. Yeah.
I'm sorry, y'all. I'm slow today.
That's all. Yeah.
Okay.
Yeah, it says
And
it starts
here's the other
55.
part. When you look
Thank
at the, I say, tinting of windows today, the back passenger is very hard to see anyhow. I think this is just really kind of a statement for us to make that, you know what, you need to wear your seatbelt, not for us as much as for yourself, but mainly the driver needs to be aware of that.
I do have a question following up on Senator Jackson's, though. There is a difference between $15 on line 57 and $25 on 69. Should we consider making that consistent?
I think at the time, and Mr. Chairman, this was before I got here, I think at the time, the $10 differentiation was between an adult
And a child.
not being strapped in, and that the child was such an egregious thing that it was a whole $10 more.
Yeah, I think that's correct.
You know, I think the 15 and 25 are extremely low to begin with. I don't think we send a strong enough message, but I think that was the purpose. The 15
Yep.
is if the adult was not wearing the seatbelt. The 25 was to the driver if the child in the vehicle was not wearing a seatbelt.
Correct. And those under
But those
8.
numbers are
Yeah.
ridiculously low.
Yeah.
All right, are you offering an amendment to those numbers, Senator?
If the committee feels so led, I would offer a friendly amendment to change those numbers. I do think there still needs to be a difference between a child and and a minor and an adult. And
Maybe 50 and
50,
75 those?
I think 50 and 75, you're reading my mind, Mr.
Okay.
Chairman.
So the bill's author, Senator Harbin, what do you think about that as a friendly amendment when we get to that point?
I think that's a good friendly
All right.
amendment. And we
What
need to send a message.
what does the rest of the committee think? I'm going to have an open discussion about this.
Mr. Chairman, I am concerned about that highness of it, especially given that this is a new law, and that it'll take some acclimation time for people to understand that they do have to wear a seatbelt as an adult in the backseat.
Isn't it true, though, they could get a warning from a law enforcement officer and go to the judge, and the judge could reduce it?
Isn't it true that you have to take time off of work in order to go to the judge to get the warning, and you have to pay for child care if you have a child while you're going to the judge to get that taken care of?
Isn't it true you still have to do that at 15 and 25?
I think I would pay the $15 a little bit more easily than the 50. I mean, that's a big jump. I mean, we talk about percentages. To me, that is a substantial.
Do you know of any other
Jump.
fine in the code books that's $15? Because I don't.
The only thing
not
I can think of that's near that, in other words, if we look at the number of individuals in our community that die in car crashes, there are two primary areas that are causing this. One is failure to wear seatbelts, and the others are distracted drivers because of cell phones. And those are the two least fines throughout the code sections.
Do you know the penalty for cell phones? Just
Cell
curious.
phone, and I lean into Senator Jones to make sure, but I want to say it's less than $100. And if you bring the device in and show that you've purchased something since the citation, that fine is actually, the case is actually dismissed. So you get a second chance. But what I'm saying is we treat two of the most dangerous behaviors with kid gloves. And I think this is very reasonable. I had a crash in my district where they missed a hairpin turn, drove into a church at an excessive speed. Two front passengers were buckled in. The rear seat passenger, who was a football player at Auburn, was not buckled in, and he perished in the crash. And that what you showed up there is exactly that. The two that took on the full impact because they had the seatbelts on lived.
Yeah.
The gentleman in the back seat did not. And I think today, if we ask anybody, would $75 have been worth it, they would have said absolutely.
And I want to reiterate what you mentioned earlier. I think this is important for the committee. And I'm looking at my friend Bob Dallas, who's going to come talk in a minute and probably remind us, but 52% of all automobile deaths are because somebody wasn't wearing their seatbelt,
And 60% if they're in the rear.
and 60% if they're in the rear.
Mr. Chairman, may I want to be clear, I very much support this bill and support that we need to make sure that we do all to encourage people to wear a seatbelt regardless of where they're positioned in the vehicle. That is not what I am suggesting here when I push back on the fine amount. I am concerned about enacting a new law, and actually the chairman brought up, or the whip, Mr. Whip brought up a great point. When we enacted a new law about cell phones and hand-free, we built into that law a second chance because we understood that it was a cultural change for folks and that they might need some time to adapt to it. People have not had to wear seatbelts in the back of vehicles for the entire existence of vehicles on the road. This is a big change for country folks like I, who grew up where we didn't wear seatbelts. And my dad probably still don't wear one in his pickup, right? And so I'm just asking for us to display some mercy, if you will, in how high we raise this fine in light of the significant culture change.
A little concerned about your daddy not wearing a seatbelt, though.
That's fair. You should be. I am too.
Could this might be, is have it for 1 year, run it at one, run them out, and then after a year, could you change it? That would be a question for Ledge Council for how that could be done.
We could certainly do that. Why don't we come up with something we can all agree with and
Okay,
live with
let's
now?
go.
We can go back and revisit it. Why don't we make it 25 and 50? That's a good start, and then we'll come back in a year or two and we'll raise it up
Okay.
appropriately. Does that sound reasonable? I see Chairman Robertson biting his glasses, so that's probably not a good news.
I'm going to do whatever the committee wills to do. I think everybody understands my personality when it comes to this and comes to public safety. I'll personally support that. I won't make that amendment, but I will support it.
Okay, that's fair. Other questions from the committee members? We do have one person signed up to speak. Why don't you go to the podium, Bob? I think everybody knows Bob Dallas from the Governor's Office of Highway Safety and himself.
Formerly. I was
Formerly,
the director of the Governor's Office of Highway Safety from 2003 to 2011. And I've been involved with this legislature doing amazing stuff for highway safety since 1990. And I've been involved with every single occupant protection law that we've passed. And Georgia has done a great job compared to our peer states. There is probably nothing you can do better to improve highway safety than requiring the occupants of the rear seats to wear safety belts. We've worked tirelessly year after year to expand the group of people that have to wear safety belts, and we've seen so many positive results. As the chairman noted, more than half the people who died as occupants are not wearing a safety belt. You're 5 times more likely to die if you don't wear a safety belt. In fact, if every occupant had worn a safety belt in a crash from 2017 to 2021, that'd equal 660 lives that we would not have lost, to your point. So I strongly encourage this committee, and I thank Senator Hardman for bringing this forward. We've been talking about this for a very long time, and when you think about the cost of health care and the tragedy that this causes to lives, this addresses it directly. And I'll close with this point. We know in Georgia we have a lot of challenges in rural Georgia, and the death rates are higher in the rural part of the state. Moreover, we don't have as much health care available. This saves lives and prevents serious injuries. So I just want to congratulate this committee for considering it. And you have a whole community of highway safety advocates out there that absolutely appreciate what you're doing.
Thank you, Bob. Appreciate your testimony today. All right, we're going to get back to the bill. What is the will of the committee? A motion to pass? A second. Now we'll offer any potential amendments. Recognize Senator Jackson.
Thank you, Mr. Chairman. I would ask that we would amend line 57 and strike $15 and replace that with $25. And line 69, strike 25 and replace with $50.
Second on the amendment. I see it from Senator Halpern. Further discussion on the amendment. Seeing none, all those in favor, please say aye.
Aye.
All opposed, please say no. All right. Passes. We have a new and amended committee sub for Senate Bill 510. Any further discussion of the committee members? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Passes unanimously. Congratulations, Senator. We appreciate your hard work on this bill.
Appreciate that. Thank you.
All right. Just because we're going to have a little more testimony, Senator, still, I'm going to ask Senator Anna Vitarte's bill, which I think is going to be pretty quick. And we've got a bunch of years combined now, and we want to make sure we give that the thorough time that it needs. So Come on down, Senator Anavitarte. We're going to be looking at Senate Bill 554, and I want to do a very personal thank you for you taking the lead on such an important issue for our fellow first responders.
Okay. Yeah, LC 5793. And I do want to say up front, thank you, Chairman Albers and Senator Robertson, for your help, your guidance, your mentorship, your advice working through this bill. It is a relatively simple bill, but I think the personal stories behind it, the impact that it has on real families and Georgians, and in particular, this situation that started with a fallen law enforcement officer in Polk County, Georgia. It's very real, and just want to thank you all for the ride. I also want to thank Autumn Cole, who's here from the Department of Administrative Services, for all her advice, help, guidance in getting this bill drafted, things to think about, not to think about, all those good things and, not so good things, to have the bill that we have in front of us today. Basically, in a nutshell, without just going through every single line, is that there are a few law enforcement officers, public safety officers, that were diagnosed with COVID-19 over the last, going back to before April 15, 2022. Some of them are not going to, or did not, or maybe were denied indemnification claims. And this basically goes back to make those benefits whole for those public safety officers. I do want to thank the Firefighters Association. I know they told me when they walked in the door, they're in support of this. I know there's, I think, a little change that Ms. Cole wants to offer as a small amendment to this bill to make it even greater. And I'm just going to leave it at that, Mr. Chairman, and ask for favorable consideration.
All right, questions from the committee members first. All right, got a question from Senator Jackson.
Thank you, Mr. Chairman. And thank you for bringing this bill. I've dabbled in the area of indemnification funds a lot myself, and so I'm very grateful for your concern and care for the family members of folks who die. I do wonder, though, is there a fiscal note associated with this bill? Do we know what the fiscal impact is? And I ask that because in previous conversations about this, there's been concern about how much this might cost the state, given the number of public safety officers who are negatively impacted by COVID.
I do have that. I did not bring that
Why don't
with
we
me,
ask
but-
Autumn to come up, if
Yeah,
that's
if you
okay?
wanna.
Go ahead, introduce yourself, if you wouldn't mind, for the committee, and hopefully you can answer some of these questions.
Autumn Cole, I'm the General Counsel at the Georgia Department of Administrative Services. So I do not believe a fiscal note was identified or requested on this particular bill. That being said, we have approved, I believe it is 34 COVID indemnification claims thus far. We have 12 still pending and an additional 17 that we believe would be eligible underneath this bill. So that's about 29 additional claims coming forward. And based on the average number of claims we've received, we do have some limited funds available within the fund. And so at this time, we believe that those limited funds would be available to cover this.
May I ask a follow-up? So can you speak to, so we've already covered some claims for COVID. So can you speak to the distinction about why some COVID folks have been covered
Absolutely.
without this bill and why we need this bill?
Absolutely. So without a presumption, which is what this bill is doing, we have had to do investigations of each of those claims and try to fit them into the existing statutory framework, which looks at whether there was a line of duty death while performing non-routine duties that a reasonable person would find to be dangerous or strenuous. It's a really specific, kind of difficult test in the age and world of COVID, where, of course, making that nexus between exposure while in the line of duty is a difficult thing to be able to find evidence that it's more likely than not that that occurred.
Let me give you an example, Senator. Let's say someone was a firefighter, EMT, or law enforcement officer, and he or she was out working every day, but then was at a training class for a few days. Did they contract at the training class? Did they contract it when they were out on duty? who really knows at that point, right? But these are people who were out there serving during the middle of a pandemic, and for such a, it's a small number, but each one of those lives who give the last measure of devotion to our community, we believe we want to give the full amount to their family.
Certainly.
All right, other questions? All right, now I know we also talked about a potential clarification in the bill. Is that correct, Autumn? Do you want to take us through what that would be?
Yes, thank you, Chairman Albers and Senator Anna Vitarte. On line 71, the department would request, having been asked to weigh in on the legislation, that a line be inserted there at the beginning of paragraph 5 that would state, "No indemnification shall be paid under this article for COVID-19 related deaths except for as provided in this paragraph." So this is going to open up a new window. So under the existing statute, there's a 2-year statute of limitations on making claims. We're going to be opening up a new application period to make sure that we give these folks an opportunity to apply. So what this does is just make sure and clarify that we never have to move back under that old statutory framework, and that instead everyone takes advantage of this opportunity now, and that moving forward that there'll be clarity in the law as to when COVID-19 related deaths are going to be paid under the statute.
I think it's very reasonable. I want to make sure our legislative counsel.
Either provide that with me or
Okay.
much slower.
Well, why don't we do this? Why don't we have her bring it over in a moment? Is there any other questions from the committee members? I've got nobody signed up to speak for or against this bill. Seeing none, what's the will of the committee? Motion to pass from Senator Payne. I got a second from Senator Robertson. Now, does anybody want to offer an amendment? All right. I think Senator Robertson wants to offer an amendment that will be that was just read by Autumn. Is there a second to the amendment? All right, Senator Halpern, you got the second. Any further discussion on the amendment? Seeing none, all those in favor, please say aye. Aye. All opposed, please say no. Passed unanimously. We have a new amended, not a committee substitute, a new amended bill. Is there any further discussion? Seeing none, I'm going to call the question. All those in favor, please say aye. Aye. All opposed, please say no. Passed unanimously. Thank you, Senator, for that. And Autumn, would you please go see Jenna?
Sure will.
Wonderful. Okay. Now.
Thank you.
Yeah, thank you. Senator Still, we've got a couple of bills for you. These were originally, I believe, 4 bills, now consolidated into 2 bills. Is that a fair statement? I want you to go to the podium because these are very important bills, and I want to make sure that everyone who might be listening online will have full access to this important stuff. Yeah. Okay. All right, I think we're going to begin, if it sounds good with you, with Senate Bill 512. And let's make sure we have the right bill number. I'm looking at LC 481232S.
Yes, Mr. Chairman, that is
All right.
correct.
Please proceed.
Thank you, Mr. Chairman. Committee, friends. Trafficking is all about the commodification of the vulnerable. Traffickers see this as a supply and demand issue, and the supply is our children and our vulnerable adults. The demand is those who would purchase our children and vulnerable adults for sex. Traffickers treat our children as a renewable resource. They can sell a gun or drugs one time, but they can sell a child over and over and over again. Traffickers aren't likely going to kidnap a child, they will coerce them. They build a prison of words to enslave the vulnerable, and fear is their tool, and they're wielding it every day on our fellow Georgians. This isn't just a young girl issue, it's not a young boy issue, it's an adult issue, it's an immigrant issue, and it's your neighbor next door. Here are the numbers according to Street Grace and Wellspring. 3,600 kids are sold for sex each year in Georgia. It seems like a big number to consider, so I'll put it to you in real terms. If you were to take every member of our Senate body and pack them into a school bus, we would have to do that 70 times, 70 times, to reach the number of children trafficked in our state. The average age of a youth being trafficked in Georgia is 14 years old. And the number of men who pay for sex with a minor in Georgia is 13,000. Human trafficking is the fastest growing and second largest illicit industry on the planet. To quote my good friend Bob Rogers of Street Grace, he said, "When we grew up, we knew where the monsters were. They were under the bed and they were in the closet. Now they work with us, they attend church with us, they play Little League sports with us, and they shop where we shop." So the purpose of this now combined bill is simple. It is to eradicate the sexual exploitation of our children and vulnerable adults. If there are no buyers, there is no trafficking. These bills will make Georgia the toughest state in the country to be a trafficker, and these bills will take from those convicted of trafficking and put those dollars directly back in the hands of the victims to help them rebuild their lives and get the resources they need. These bills presented today are done with the help of the following people and organizations and the culmination of over 6 months of work. Bob Rogers of Street Grace, Christian Murphy of Wellspring, who's going to speak to the bill, Bruce Deal of City of Refuge, and of course, my closest advisor in this, Heather Fisher of Thomson Reuters. So with that, let's break down the bill. It started as I said, as 3 bills. Thanks to the amazing work of Holly Carter and Legislative Council, this has been amended into a single bill, which we're looking at. So if we look at Part 1, Section 1, starting at line 26, and as we go through, it's describing the creation of a new commission, the Victims of Human Trafficking Fund Commission. And the reason we're doing that is we have a safe harbor, but it is only for children, and it is only funded by state dollars. What this bill is going to do is be a new commission to protect all those who have been the victims of sex trafficking, and it will be funded through the act of civil forfeiture. We have civil forfeiture in the state, but what is different about this is that those funds, rather than going to a local DA, if they have been seized by someone who has been found guilty of that act, those assets will be put towards the fund. And then those funds, as collected, will be used only to distribute to the victims of sex trafficking. The funding also comes from a $2,500 fine, which is an increase from the $1,000 fine we currently have on the books. And the overall idea of this is to expand access for assistance to trafficking victims and fund it with those assets taken from those convicted. The enabling legislation from SB 12 leads to Senate Resolution 616, which is the constitutional amendment. The language that is in our bill, but I'll read for those following along, is that if passed, the ballot language that would be on everyone's November ballot would say, yes or no, shall the Constitution of Georgia be amended so as to allow additional penalties for criminal cases in which a person is adjudged guilty of trafficking an individual for labor servitude or sexual servitude, to fund the Victims of Human Trafficking Fund to pay for care and rehabilitative and social services for individuals in the state who have been sexually exploited. In Section 2 of the bill, beginning on page 8. This gets into the hotel, motel training requirements. The good actors in the hotel, motel industry have done a wonderful job of creating training programs, their own training programs, but many of the lower-end hotels, will say motels, frequently use housekeeping services that are not employees. They're not held accountable for any training. And so this specifies that they will follow the CJCC guidelines, which are already available, but it's going to require ongoing training and focusing to ensure that, that they are doing this consecutively year after year. Section 2.2 has created a little bit of question, so I'm going to address what the bill says and then also address some of the questions that a couple of the members have brought forward to me. This is under the section of masturbation for hire, that we are not going to charge a child with that act through sex trafficking. The question was, are they 17 or older, or where is it, 18 or older? What is the question on that? What is the statute on that? So the OCGA clarification says, in Georgia, two circumstances lead to a child under 17 being tried as an adult superior court. The first is the seriousness of the crime. The superior court has exclusive jurisdiction over the trial of any child 13 to 17 who is charged with committing any of the following offenses. And this is an OCGA 15-11-560. This was a long debated question with Ledge Counsel, and they assured me that it needs to be as ages 17 and under. So this bill was created not only with the help of our top non-governmental organizations who support victims in this area, but also with the approval and endorsement from the Lieutenant Governor's office, the Attorney General's office, the Governor's office, and members of the Grace Commission. We did not take this bill lightly. This has been, as I said, 6 months of work, working with every NGO that we could, working with the Prosecuting Attorneys Council, working with organizations, even consulting with GACTL on different parts of the bill with the Hotel Motel Association. We've got a problem here in Georgia. We are ranked 7th in the country for human trafficking, and this is not something we want to, as much as we like to say we're number one for a lot of things, we have got to make ourselves 50th in this. So with that, Mr. Chairman, I'm happy to answer any questions from the committee.
Thank you, Senator. Very thoughtful and thorough work on bringing this bill together, and I sincerely appreciate the amount of work and the collaboration that you have taken the lead to bring this forward to us. First, I'm going to ask for questions from the committee members. I have a question from Senator Jackson.
Thank you, Mr. Chairman, and thank you, Senator Still, for bringing this bill. I work regularly with people who are victims of trafficking, and so anything that we do to help in this is a gift. But I know you said that you had long conversations about the 17-year-old age status, but can you fill it in for us? Because, we've been really clear. I feel like we've been very clear as a body that when it comes to human trafficking, that we make sure children are treated as children. And so I'm just confused about that 17, 18-year-old piece, because a child, my understanding, is 18. And so can you just speak to how you came to this place of it only being 17? I know you read a code section, but I need some more words, please.
So
Hang on a second here. Well, let's give the bill's author first, and then
as
we'll
Senator Payne said, that is what's in the juvenile code.
But aren't we creating the rules right now? Like, I don't understand.
We can't change it in one bill if it's consistent throughout the rest of the juvenile code as that.
I think if we can't, then who can change it?
Well, you can't change it in one little spot if it says 17 everywhere else throughout the state code.
I think I understand what you're saying, but I think, it's going to get, if we're going to change this, if we're going to be consistent, we're going to say children are children, we got to start somewhere. And so unless you're telling me that it's somehow illegal for us to start here and say that 18-year-old and above, then I don't understand why we can't start now with this part, and we can continue to work systematically. But either we believe that children are children and that they should not be prosecuted as adults for sex acts because they're being exploited. Either we believe that or we don't. And if we believe it, I feel like our language needs to align with that. And I don't think it's acceptable for us to say, well, that's what is in the code. Therefore, we're the ones who write the code. So
I understand that.
I would like help with
I
getting there.
advocated for exactly what you're saying.
Okay.
The way it was explained to me by legislative counsel here and by the number of current and former prosecutors that I've spoken to about this, and if PAC is in the room, I'm sure they can clarify further. But the basic explanation to me was this, is that if we wrote 18, because there were so many other places throughout the juvenile code where it says 17 and older, that we would create a gap and that there would be some ambiguity that could force 17-year-olds to be charged with this in a way that we would not want. It would be an unintended consequence because we would create a one-year opening of those victims where if our prosecutors weren't exactly in line with where they needed to be, and I'm not an attorney, but this was their explanation to me, was that we had to treat it that way. And I'm sure there are brighter minds in the room that can speak to that. Ledge Counsel, have you been communicating with Holly about this? Or? Okay.
All right, we're going to keep moving. I'm going to give Senator Robertson a chance to weigh in here.
Well, and I think, and to Senator Payne's point, if you were charged with a criminal offense in Georgia and you are 17 years old, whether it be masturbation for hire, whether it be stealing a car, robbing a convenience store, you are charged as an adult in Georgia at 17. While I appreciate the passion, children is not the term that is used to determine adult from child. It's age in this particular situation. And so that's why 17 and up is the is the way it's written. And listen, I read in the media occasionally where they'll say, young men killed or children killed in drive-by shooting or whatever, and they'll list their ages as 17 and 18. And while I think that's a great headline, as a matter of fact, but in the reality of the law, 17 and 18-year-olds are adults. And so as much as we may not like it, it's the reality of it. And we cannot cherry pick as we go through. I know we've had to write unique wording and prostitution, pandering, and other type of crimes to make sure that we don't inadvertently catch those who are under those ages who may be victims of sexual trafficking and make them criminals. But I think in this case right here, I think 17 is the correct under the law.
And let's have someone who's very familiar with that, Senator Payne, weigh in.
And I would just say to my good friend, if we want to draft that bill, I'll be right there signing with you as far as raising the age. But I think this is trying to work within existing law. And to work within existing law, that's why it's written this way, because it can't be ambiguous to the law the way it currently stands. But I mean, just as I've told people all the time, 17-year-old has to go stand for a jury of their peers in the adult court after being charged with a crime, and they're standing not before a jury of their peers because they're not old enough to serve on that jury yet. So I understand your questioning, but the law that already is on the books now is just reciting the law as it is right now. And so, and I don't think you can change that overall
Right,
law
no.
and structure with just this one bill.
I just want to push back a little bit on that, if I may, Mr. Chairman. So I understand for other crimes that we've said 17 and above. First of all, we are not considering these people this is not a crime for minors. It's not a crime for minors, right? That's what we're saying. We were saying they are victims of trafficking. That is what we're doing here. And when we have defined victims of trafficking or sexual servitude, we have included anybody who was under the age of 18 in our code section. I can actually tell you the code section. So in code section OCGA 16-5-46A8, we've said that when it comes to sexual servitude, it's any individual who is under the age of 18, not 17, but 18. That because we have made a decision as this body to treat minors when it comes to sexual trafficking as a different category than all the other than other crimes. That's what we've done, and so I'm asking for consistency here, and that would be the consistent thing would be to make that age 18.
I appreciate your comments. I think that if nothing, we're inconsistently consistent in the code. All right, other questions to committee members? All right, seeing none, we've got a few folks that want to speak, so I'm going to ask you to stay at the podium if you wouldn't mind, Senator, so you can help to answer or fill in any blanks for some of these folks. First up, Maisie Lynn, would you like to come down, please? Why don't you come down to the witness microphone 2 in the middle?
Thank you, Chairman Albers. It's nice to be here. I can't believe it's taken this many days, this session, to appear before you all, but it's good to be here. I believe that with the changes that were announced regarding the changes in these bills, that this is really the only one that I have issues with now that the way they're combined, but you can help me figure that out because I have not seen these subs. As Senator Still mentioned, we did discuss the forfeiture provisions that are the civil forfeiture provision provided in this legislation. When I saw it, it was in lines 148 through 151. I don't know where it sits now. What we really have appreciated from the beginning is the senator's commitment to ensuring that the citizens of Georgia don't lose access to their property until they've been convicted of an offense. We realize the gravity of these offenses warrant this sort of attention, but certainly appreciate that he is being very intentional in making sure that a conviction occurs before the state begins to take property away from someone. One other aspect that we would raise, and I, again, haven't seen the sub-language, but in the version that was first filed, it read that any real or personal property utilized by a person who has been convicted of any of the offenses provided in subsection A of this code section is declared to be contraband and subject to forfeiture.
Yeah, this is line 153 to 156 for
Thank
everybody
you.
looking. In the new,
so it is still that same
it is
language.
that, yes.
Okay. So our only suggestion is a minor modification to ensure that not only do you have a conviction, but that the property is taken is actually property that was used in furtherance of the crime, which is usually the concept of why we would want to take property. If someone uses their car to transport drugs, you'd want to take the car away because it was used as part of the offense. So, for instance, I mean, our recommendation that I can provide to you in writing if you're willing to consider it, is that upon conviction for the offenses provided in subsection A, so the same set of offenses as are in lines 153 through 156 now, any real or personal property utilized by the defendant in furtherance of such offenses is declared to be contraband and subject to forfeiture, et cetera, et cetera. It is our understanding, as we read the plain language of this current legislation, that you would be opening the door to taking anyone's personal property because there's no nexus between what it's utilized for in the current version.
Maisie, I hear what you're saying. My concern is somebody walked, and the only thing they're going to take is their sneakers.
I'm sorry.
Well, I mean, if somebody walked and committed some of these heinous acts and didn't take their car, they didn't do their house, it did, was at a hotel room, then what is there really to forfeit?
Well, we don't use forfeiture typically as a punishment scheme. It's usually to kind of take back proceeds, take back sort of this like windfall concept. So like, for instance, or to take back sort of the tools. So like if there's a home
No,
where
I understand.
someone is being.
So, but if somebody was in their house
Yeah.
and they used the internet and it was coming out of their house,
So I think reasonable, depending on whether or not the state could prove that both the home and all of the computer equipment were used, then maybe both of those things are subject. But if the state can't prove a nexus between the actual home and maybe they can only prove the computer peripherals and whatever, that is my point, that you potentially are taking away a lot more property than is, truly lined up with the offense that you're worried about.
Let's let Senator Robertson.
Macy, and to be clear, and I think on 160, it may clear up a little bit of your concern, but and not necessarily, and you helped me with the seizure part, because most of my seizures are related to narcotics.
Sure, right.
So not only is it the tools used to facilitate, but it could be fruits of the crime.
Exactly.
So if somebody is trafficking somebody and they're bringing in funds, and they use those funds to buy a house,
Right.
they use those funds to buy a business or whatever else, once the case is made against them, then the state would have the opportunity to file a lien against those properties and, of course, let the courts decide. And then those resources be converted and into the property of the state, if you will. So tools and anything from fruits of the crime, we would say, yeah. But
I think we're agreeing on that.
But if somebody's renting a car from Hertz Rental, and they're using it to transport victims of sex trafficking back and forth, that vehicle should not be eligible for seizure because Hertz had no idea, unless you could show, Hertz has no idea their vehicle was being used. So these are only things that we could tie directly to the crime, would you say?
I would agree.
All right, and I
Okay,
think
just wanna make sure.
let's follow up on what
Yeah.
Senator Robertson was citing, and I realize you don't
Yeah,
have this in
it's-
front of you right now,
Right.
Maisie, but right after that, beginning on line 158, section 1-2, I'll get to the 160 where it starts, is any property which is directly or indirectly used or intended for use in any manner to facilitate a violation of code section lists out of the sections, and any proceeds declared to be contraband, and no person shall have a property right to them. So works directly,
So perhaps
indirectly, or
it's all been
used.
fixed. But that's the trouble with not being able to access.
No, we understand.
those when you're-
We're combining bills, so that happens at the last moment when we're right before crossover day.
Mr. Chairman, if I may too, it was written that way because we wanted to Senator Robertson's point, if someone was using a hotel without the knowledge of, nice hotel brand A, the owners clearly didn't know, the managers were unaware, guests were performing illicit acts in the room, we didn't want to create a situation of liability for that hotel to be part of that because they were unaware of the circumstance with it. And so we wanted to ensure that we were not punishing people that had no idea of what was being utilized. So it was being utilized in the crime, but without any knowledge or consent
Of the owner.
of the owners.
So I may certainly see that that's the plain language currently today that sits in 16.6, 13.3, as laid out in 158 through 162. But still, back up at 153, that same kind of nexus is not included. It's simply not there. It could certainly be modified so that you have line 153 lining up with what's at 160. And that would cure my concerns. But this idea that you've just got any real or personal property utilized by a person who's been convicted of this offense. So utilized how, utilized for what, utilized when. I mean, this is, you've got the language down there like you've just pointed to in 160. I think it's just finding a way to put that together because it doesn't reference each other.
I think the concern is what is utilized? Utilize it to commit the crime, or is it something you just use every day?
Utilized in your
Yeah,
life
yeah,
because,
yeah.
I mean, it's.
I think the intent, yeah.
I understand the
think-
intent,
no,
but the
no.
language doesn't
No,
match it.
I understand what you're saying.
That's all I'm saying.
Commission of the crime?
Of,
Let's hang on. Shh. We're not going to have a round robin on this.
Yeah,
Appreciate it. I
I've
think you
raised my
bring, I
issue.
think you
You've
bring up
heard
a
me.
valid point that we're going to have
Thanks.
some discussion on. Legislative Council will talk to the bill's author about that one. All right.
That's all I could ask.
Anything else?
Yes. On this issue of 17 and 18-year-olds, it is a policy matter for you to decide, but you have as a body, as has been mentioned here before today, decided in the context of prostitution just in 2019. And it was in this context of human trafficking that it was decided that in 1669, the statute was amended so that a person 18 years of age or older commits the offense of prostitution when he or she performs or offers or consents to perform a sexual act, et cetera, et cetera, et cetera. And masturbation for hire covers similar sexual acts performed for money or the substantial equivalent thereof, which loops you back to the concept of trafficking victims, which is what took us out, as Senator Jackson was saying, takes us out of the typical rubric of how we charge under our laws. If you were to change this language to 18 years of age or older, that would actually be consistent with your recognition that 17-year-olds who are engaging in the acts defined as masturbation for hire as victims of trafficking are worthy of your protection. And that would, like we've said, also be consistent with the ways that you have modified the prostitution statute to acknowledge the same, that there are certain acts that these children are being forced to perform. Masturbation for hire is one of them. And because we treat 17-year-olds as adults, this language is needed for you all to truly protect the people that you're trying to, the children that you're trying to protect in this context and in this way.
Very good. Thank you. All right. I appreciate your testimony. We're going to hear from a couple more folks here. Mac, why don't you come on down to the witness microphone number 2, please? No, it's fine. Thank you. Appreciate you.
Mr. Chairman, members of the committee, my name is Mac Parnell. I'm the Executive Director of the Georgia Faith and Freedom Coalition, and just want to thank the committee and thank my good friend Senator Still for his hard work. I just remember months ago I called him. I think it might have been even on a weekend, and I was asking, we were just catching up. I was asking what he was doing. He had just stepped out of a meeting on this very bill. So I know this has been a passion project of his, and the Georgia Faith and Freedom Coalition looks forward to the day when Georgia is #1 in the fight against human trafficking. So I know the hour is late, but
Amen, Mac.
thank you so much.
Great comments. Christian, is that right? Okay.
Good afternoon, Chairman and members of the community. My name is Christian Murphy, and I'm the CEO of Wellspring Living, a nonprofit organization that has supported sex trafficking survivors and those at risk for 22 years. I am very much in favor of Senator Still's bill to make sure that we have enough resources to support the women and children that we serve, but also to lessen the burden that children experience by coming forward, and also some of the concerns that they have about the risk of facing law enforcement. So whatever we can do to make sure that there are adequate resources and support is really helpful and important to the work that I do, but also making sure that we do have ongoing advocacy through our hotel and motel employees by making sure that they are properly trained to identify victims, but also perhaps perpetrators, to make sure that we're punishing them for the crime that they so rightfully deserve. Just wanted to say that in favor of this particular bill.
Thank you, and thank you for all the incredible work you do every day. We appreciate it.
My pleasure.
Thanks. All right, we're going to take a 60-second recess while I confer with the bill's author. Make any final comments, and then I think we've got 2 adjustments that were found that I think will help perfect the bill. So Senator Still, would you like to make any final comments?
Thank you, Mr. Chairman. I agree with Senator Jackson 10,000%. I wish we could raise the age to beyond. Victims are victims. It shouldn't matter what their age is. I hate that we would even have to have the conversation. We need to just ensure that we can get the age as high as possible. So if it's possible with Ledge Council to raise that to 18 and it doesn't conflict, we absolutely should. I agree 1,000%. And in the spirit of cooperation, I think that the language proposed by Maisie from Gactyl, if that doesn't weaken the bill and it helps clarify it and make it stronger, by all means, we should. So those are our two great friendly amendments. I think if we can make that a single amendment to ensure that we've made this the best bill possible, then we should do it and vote accordingly.
Thank you, Senator. If I could ask Jen, if you come down to maybe the witness microphone 3 there. First thing we need to do is have some action on the bill. Do I have the will of the committee?
So moved.
I've got a motion from Senator Williams. I got a second from Senator Jackson. Now, there's probably a couple of amendments. I will recognize Senator Jackson for the first one.
Thank you, Mr. Chair. Request that we. I move that we amend line 193 by striking 17 and replacing that with 18 years of age or older.
Okay, I've got a motion to strike 17, replace with 18 on line 193 of the bill. I have a second from Senator Halpern. Any further discussion on the amendment? Seeing none, all those in favor, please say aye.
Aye.
Opposed, please say no. Amendment passed unanimously. Now, would somebody else like to offer a second amendment as outlined by our legislative counsel?
You're going to give us the language?
All right, I think Senator Halpern, she had her hand up. So
Okay.
she's going to offer an amendment. Who's going to second the amendment? She's going to say it'll be Senator Jackson. Would you please read amendment number 2?
Okay, we'll do on line 153, we're gonna, after the number 2, we're gonna put, upon a conviction of subsection A of this code section, any real or personal property which is directly or indirectly used or intended for use in any manner to facilitate a violation of subsection A of this code section is declared contraband and subject to forfeiture in accordance with the procedures set forth in Chapter 16 of, sorry, that's basically going to replace all that language.
That's amazing. It's exactly what Senator Halpern just
Right.
told me. So she's a astute attorney. Okay, so we have a motion and a second for amendment number 2. Is there any further discussion for amendment 2? Seeing none, all in favor, please say aye. Aye. All opposed. That passes unanimously. We have a new amended committee substitute for Senate Bill 512. Is there any further discussion of the committee members? Seeing none, all those in favor, please say aye. Aye. All opposed. Passes unanimously. Congratulations, but stay right there, Senator, because we have now the constitutional amendment that will go along with your enabling legislation. I'd like everyone to direct themselves to, we've got Senate Resolution 616, that is LC 481006, and I will turn it back to you, Senator Still.
Thank you, Mr. Chairman. As I read in my opening comments, this is the constitutional amendment that we will all have on our ballots in November for the creation of this fund. To restate, this does not replace or compete with Safe Harbor in any way. This is for all ages of sex trafficking victims that will be funded not through a fiscal note, not through our state budget, but through the act of civil forfeiture, which the language in the aforementioned enabling legislation, I think, is much better. So that is all that those 2 pages will accomplish.
All right. Any questions? If not, any questions before we move forward? No? All right. Hang on. We're going to do a quick question.
Just for the record's sake, the question that is written for the ballot is very difficult to understand, as is often true with the constitutional amendments that we propose. But I felt like it needed to be named out loud on the record that it is not very accessible language.
Thank you for your comment, Senator. I will tell you, out of all the ones I've seen, this might be the best one, so that could be saying something. All right, I've got a motion from Senator Williams. I've got a second from Senator Payne. Any further discussion from the committee members? Seeing none, all those in favor, please say aye. All opposed? Passed unanimously. Best of luck and rules for both of these very important bills. Great job today, Senator.
Thank you.
All right, that is all the business in front of this committee. Quick update for logistics. This is the last committee meeting before bills that will be eligible for crossover day, so no more Senate bills when moving forward from this committee. We do plan, though, to have a committee meeting next Wednesday. Senator Parent has a bill, and she wants to bring some people in to do some testimony on something she wants to work in the off session, as well as we'll probably hear a House bill or 2 just to keep the process moving. And if that, I will entertain a motion to adjourn.
So moved.
I've got a motion to adjourn and a second from Senator Jackson. All in favor? All right, this meeting is hereby adjourned. Thank you.